Hello and welcome to episode 16 of the Immigration Podcast. Today we're going to bore you with this PowerPoint presentation, but it's very important information. It is about the ending of TPS for various countries that currently are served by TPS. It's just me tonight, so we're going to try this to see how it works. In the news, you've seen a lot about Haiti and TPS recently. Haiti is the most recent country to have to deal with the ending of TPS. That issue is currently in the courts. We can expect some sort of ruling on that in the very near future. Currently, TPS is still in place for people from Haiti, but that does not mean you should rely on TPS being there forever. So let's talk about what happens if TPS does end. TPS was never designed to be a permanent program. When you read the statutes, when you read the code, it is something that is temporary. It is in the title, temporary protected status. It also does not ever confer a permanent status to any of the individuals that have received TPS. But a lot of people didn't understand that. A lot of people don't understand that it is temporary, and the government, which gave it to you, can take it away. And because of that, a lot of people along the way, while they've had TPS, have lost the opportunity to apply for other types of more permanent status. And an important consideration about TPS is that it never actually cured or changed any of the other immigration issues your case might have had. So if you have an old deportation order, it's still there. If you have an illegal entry, it's still there. So when TPS ends, your work authorization will end, regardless of whatever date it sets forth in your work authorization card. It ends when the TPS ends. And you revert to whatever category or immigration issues you had before you were granted TPS. So what kind of things do you need to think about if you're getting prepared for TPS ending? In the current climate, as you've seen, a lot of people are getting detained. So you want to make sure that you've got some things in place for these situations, that you've got child custody arrangements in place. Who's going to pick up your kids from school if suddenly you're in ICE detention? Who's going to take care of them? Do you have guardianships in place? If you're taking care of an elderly parent, is there something in place for that? Making sure you have power of attorney assigned to somebody for any medical issues you or your family members might need. For banking issues, if you do get deported, what about your assets that are in the United States? For any legal issues, helping you obtain an attorney, helping you obtain representation, or dealing with some of those other issues, guardianships and property and all of that. Phone numbers and addresses. Make sure you're carrying these things written down. We all have cell phones now and can't remember people's phone numbers or their contact information. So have those things written down if you think being detained may be an unfortunate thing in the future. If you are a small business owner, so many people that come to the United States open up small businesses. Make sure you have a plan in place. Who's going to continue to operate that business? Or is it going to be able to be sold or maintained or passed on to U.S. citizen or permanent resident relatives? Make sure you have copies of all your personal records, passports, birth certificates, all those sorts of things. Why this is important is because you've got to prepare for a situation. If TPS ends, will you find yourself in a situation where you are detained? Remember, right now, if you are someone that entered the country without inspection, typically what we call, the illegal entry, you are someone that the government says should be mandatorily detained. Now, we have a class action case out in California that says you should not be mandatorily detained just because you entered the country without inspection. But as of last week, the Fifth Circuit Court of Appeals, which governs Texas, Louisiana, and Mississippi, has said no. If you entered the country unlawfully, then you are subject to mandatory detention. So as you can imagine, if ICE picks you up You expect them to get you on a bus to Texas or Louisiana as quickly as possible. So you want to make sure that if you are a current TPS holder, you're doing the things you need to do to make sure your family and your kids, your job, your employment, your business, all that is taken care of. Prepare for potential arrest or detention. Gather your documents now. Gather your proof of identity. Gather proof of your family ties. Gather proof of rehabilitation if you have any old criminal history. Gather a sponsor. Make sure you talk to someone that's a citizen or a permanent resident that's willing to be a sponsor if you can apply for bond. Look for documents that show your proof of residence, your employment, that you have letters from friends and family and community members that support you and would support you in a release for bond. If you have an old removal order or you have an old criminal conviction, you really ought to be talking to an attorney as quickly as you can. You want to make sure that whether or not there's a way to challenge that old removal order, reopen that old removal order, challenge the old criminal conviction, because those old removal orders and those old criminal convictions can put you into a category now where you would be subject to mandatory detention. Even if you have those criminal convictions and even if you have old removal orders, you may still qualify for what's called a reasonable fear interview. This means that you have a fear of being harmed if returned to your country. And that's something that you would ask for in a detained context. You also may have some options to stay in the United States. There's a variety of things, and we'll talk about them later on, but those are all things that you're going to want to sit down with your attorney and review to see if any of those apply to you. For people that are interested in TPS ending and are trying to support people who've come to this country, you want to be very cautious about how you do that. You've seen a lot of the protests and a lot of things on the news. You can observe, but you don't want to put yourself in a position where you are considered to be obstructing. That's how you get arrested and things don't go so well. You can video, you can record the names and contact information of people who are around. One thing I always add is record audio as much as video. Make sure that you are hearing what's going on, because with all the noise and all the things that go on, a lot of times the verbal exchange between people who are being detained and agents can be just as important as the visual aspects. You should have phone trees set up so that if you are detained, your family knows who to call, and people who know you know who to call to get ready to try to seek bond, try to seek release, try to determine whether or not you have some sort of immigration benefit or an opportunity to get out of detention if you can. Let's understand the types of entries that you might have into the U.S. and what kind of risks these different types of entries may have if TPS ends. If you were inspected or admitted, you came on a visa of any type and you just overstayed, there's generally very low risk that you're going to be detained or detained for a long period of time and not have a bond hearing. If you entered without inspection, I almost think the moderate doesn't apply anymore. I think you're going to see a very high risk of being detained. Like we said, litigation is ongoing, but right now, the Fifth Circuit has come out and said that no, mandatory detention does apply to individuals in this circumstance. The immigration courts, the judges, have been instructed to not apply the California class action case. So you're going to be in a situation where you're going to be facing detention and you're going to have to fight for the ability to seek a bond. If you were someone that was paroled into the United States, either paroled for TPS purposes or paroled for some other type of purpose, there's a fairly low risk that you're going to face detention moving forward, but it's not zero. And if it's been more than 2 years, much more likely that you will not be detained. But if you entered on any type of parole in the last 2 years, there's a real likelihood that you may be detained and face what the government calls expedited removal. anyone that's subject to expedited removal, there's not only a high risk that you might be detained, there's also a very high risk that the government may impose upon you what's called asylum cooperative agreements. And that is a list of countries, Ecuador, Honduras, Guatemala, Paraguay, a few others, that the government can say, no, you need to go there and apply for asylum first. And if they turn you down, well, then you can come back maybe and apply for asylum here. That's not going to be easy, and that's not going to be good. Third-party country rules, any individuals that traveled through countries on their way to the United States, they may be subject to removal and detention because you have to show that you applied for or were unable to have asylum in those countries. Immigration bond determines whether or not you can be temporarily released. And that depends on things that the judge considers, whether you are a flight risk or whether you are a threat to public safety. In the current administration, things like entering without inspection, things like being in the United States for a long period of time without applying for some type of relief, those can be considered flight risk and threats to public safety. It's not the way it used to be considered. If you are subject to mandatory detention, either because of unlawful entry or because of a criminal conviction, you're not eligible for bond. You may, however, be able to seek review of any DHS custody determination. There are guidelines for 90 and 180 days. There's no set in stone number anymore that you have to serve a certain period of time before you're eligible to seek custody review from DHS, or when you can go into federal court to look for habeas relief there. But be prepared now. Be prepared before you get detained if you need to apply for bond. And that's the things we talked about just a few minutes ago. Gather proof of your family connections. Gather proof of where you live, your employment, your business, letters of support, who's going to be your sponsor. Show your ties to the community and your family ties in the United States. Now, if you do get detained, you want to know your rights. But you'll see a lot of pamphlets floating around about knowing your rights. And it's really not as straightforward as you have a right to not talk to the ICE agents. You have a Fifth Amendment right to not incriminate yourself. For some people, that is true. If you have no status in the United States, if you did not enter lawfully, well, then maybe exercising your Fifth Amendment right and standing silent is your best option. But it's not going to be the same for everyone. Everyone has constitutional rights. You have the right to exercise that Fifth Amendment privilege. You have the right to exercise due process and all those things. But when you talk about your right to remain silent, it is dependent on specific things. If you are here in the United States in a valid immigration status, pending asylee, or you're a permanent resident, or anything like that, you have an obligation to carry your identification documents and to provide that information to an immigration official when you are requested to do so. Here in the state of Ohio, where I'm at, we also have a law that local law enforcement may ask you your name and your date of birth and your address. Now, you don't have to show ID, but if an officer asks for those things, you do have to provide that information. Failure to do so, regardless of your immigration status, can be a separate crime that can result in your arrest. And that's not going to look good when you're looking to apply for a bond down the road. The other thing to keep in mind is the jurisdiction of Border Patrol. When you are within 100 miles of an international border, Border Patrol has the authority to ask for identification information, even from United States citizens. So here in Northern Ohio, where I'm at, because of the lake in between us, we are within 100 miles of the Canadian border. There are Border Patrol in Cleveland. And if they ask me for identification, I have to provide that to them. That's part of the statute. Now, you do have the right to say that you want to consult with an attorney. You want an attorney to review anything before you sign it. Those are all good things and things that you have a right to do. If you are detained, and if TPS ends, then even if you're not detained and TPS ends, you need to start looking for what other options you may have available to you. As we said, TPS was never intended to be permanent, and if you rely on it forever, you may find yourself subject to the whims of not only this administration, but a future government administration or a court ruling that ends your TPS for you. So some of the things that you need to be taking a look at is whether or not you have old immigration cases and what happened to those. If you had old immigration cases, was it dismissed? Is it just on an administrative closure? Because then it can be brought back by the government. Depending on how long you've been here, you may have other issues, other forms of relief that could be provided to you. Some of the common forms of relief that many people think about in the immigration context is asylum. Do you have a fear of persecution in your home country? If you don't qualify for asylum, do you maybe qualify for withholding of removal or under the Convention Against Torture? Similar to asylum, it doesn't put you in a path to a green card. It's a little harder to prove that you qualify for withholding of removal, but it is another form of relief. If you have been in the United States for more than 10 years and you're a person of good moral character and you have qualifying United States citizen relatives, you may qualify for what's called cancellation of removal. If you've been the victim of a crime or human trafficking, which includes forced labor, you may qualify for a U or a T visa. If you have been abused by a U.S. citizen or permanent resident, spouse, parent, or child, you may qualify for under the Violence Against Women Act. If you are under the age of 21 and you've been abandoned or abused by one of your parents, you may qualify for special immigrant juvenile status. And if you're married to a U.S. citizen or permanent resident or have a U.S. citizen or permanent resident parent or child, you may qualify for adjustment of status. There are specific requirements for that with respect to legal entries, but there are also waivers that are available. Criminal records will complicate any of this. So you're going to want to make sure you're being proactive. Sit down with your attorney or a legal aid services provider and discuss these options. And it's really in your best interest to do it before an official end to TPS and you're trying to do it from a detention center. Talk a little bit more in depth about some of these options that are available to you. Credible fear and reasonable fear. And reasonable fear applies to individuals who have been previously deported or maybe don't qualify for credible fear because of a criminal conviction. If you have a credible fear of being harmed or persecuted in the country that you would be returned to if deported, this can allow you to have a full hearing in front of an immigration judge. Your first step is an interview with an asylum officer. If that officer determines that you do not have a valid, credible, or reasonable fear, you can request for an immigration judge to review that. And if the immigration judge approves it or the asylum officer approves it, you will have an opportunity in court for a full asylum or withholding of removal hearing. Now, just because your TPS ends and you may be detained doesn't automatically give you these protections. These are protections that you have to specifically ask for, and you have to specifically articulate that fear that you have of being returned. If you are from Haiti, and because Haitian TPS has been in the news most recently, there are specific asylum and reasonable fear challenges that Haiti experiences that a lot of other places do not. The laws for asylum require that you have to show that you'd be harmed or persecuted based on your race, your religion, your nationality, your political opinion, or a defined particular social group. And that can be a lot of things that you'd want to speak with your counsel about. You also have to demonstrate that this is something that either the government is complicit in or that the government is unable or unwilling to help you protect yourself. Where this comes into play in Haiti is the courts have been pretty unanimous of saying that generalized violence and generalized crime, overall bad country conditions, are not enough to qualify for asylum or any of these types of things. And the reason, who knows what the reason is, but the reasoning that the courts applied to it is that because if these conditions are equally bad for everyone, then you individually cannot show that you are being targeted for one of these protected grounds. Also keep in mind that for asylum relief, there is a 1-year filing rule that you have to file for asylum within 1 year of entering the United States. However, changed circumstances, if there's something new has happened in your country or there's been a new threat to you personally, those can restart that clock. You don't necessarily get a full year, but it can be an exception if you're filing outside of that 1 year period. And this one, long-term residence, 42B relief, this is cancellation or removal. I talked about it briefly before, but this, you have to have been present in the United States for 10 years. You have to have a qualifying U.S. relative. It's a spouse, a parent, a child. There is a very high standard for obtaining this type of relief. You have to show that it would be an exceptional and extremely unusual hardship to your qualifying U.S. spouse, parent, or child. But if your TPS is ending, and if you find yourself in immigration court facing deportation, and this may be a path that you want to take a look at. So, some resources to protect yourself and to be involved in trying to structure what your defense is going to be if TPS ends. I suggest go back, take a look at episode 9 of our podcast. Myself and one of my partners here at our firm did a lengthy podcast on trusts and powers of attorney and documents needed for childcare, businesses, all those sorts of things. Also, our blog at removal-defense.com. Are you financially prepared if ICE comes to your door? An article that goes over some of those same things that Michael and I talked about. As always, if you have any questions, feel free to call or email us. The most important thing, make sure you are prepared if TPS ends. And be prepared before it ends. Thanks. We'll see you on the next episode.